SJC-12436, Commonwealth versus Niemic.
Mr. Reardon, in the words of Yogi Berra, it's deja vu all over again.
Yes.
Mr. Niemic is back, and you're back with us.
Yes.
Okay, you may proceed.
Good morning, Your Honors. Theodore Reardon on behalf of Mr. Niemic. With me today is my partner, Deborah Reardon. The first issue presented in this case is the improper testimony by the substitute medical examiner, Dr. Niels.
Didn't you have an agreement about that?
No, there was no agreement on that. No.
So the Commonwealth got it wrong?
Yes, they do.
Okay.
It
How
was
are we going to tell one way or the other?
Well, by looking at the transcript. And the transcript indicates that the Commonwealth tried to introduce one small portion of that autopsy report that was favorable to the defendant. When they did that, defense counsel said no objection as to that. So it's very clear that defense counsel was agreeing as to that one small portion.
You know what concerns me, Mr. Reed? I agree that that's what's reflected on the transcript. But, and I know this, we still have to analyze this under substantial likelihood of miscarriage of justice, but the judge, right off the bat, says, I'm following Nardi. You want to object to something in the autopsy report? I am following Nardi to the letter. You are on notice. And so maybe despite being limited to the lip issue, maybe Justice Lank's point is correct, that there's sort of an implicit agreement because the judge could not have been more direct about it.
I agree, absolutely. But nevertheless, what defense counsel said was as to that. Why he then didn't object to the rest when there's no reason why he should have objected to it. There was nothing favorable about that testimony. There was nothing to be gained. There was no quid pro quo ahead of time that if you let this in, we're going to let that in. Defense counsel should have objected, and there's nothing more to be said about it other than it was ineffective, frankly, for him not to do that.
Why isn't it, we've never really addressed the issue. I wrote a concurrence in Monteron about whether or not the observations of the substitute medical examiner that rely on the autopsy report, where it's not an analysis, but just how deep the wound is, how far it is from the heart, whether that's testimonial. I mean, Justice Breyer could not be more clear in Williams versus Illinois that that's just not testimonial, and many state courts seems have come out the same way. I'm not sure I understand how many inches from the heart or how tall somebody is testimonial under the United States jurisprudence.
Well, so I think what you're saying is the facts as distinguished from the opinions in the autopsy report. Can those come in? Yeah. I think the answer to that is, well, basically it's hearsay. I mean, as far as what the observations of
Nardi, first of all, Verdi didn't do anything about the hearsay exception when Melendez-Diaz went to the United States Supreme Court. They have nothing to say about our hearsay exceptions. But in Nardi, there's a distinction. Justice Cordy makes a distinction about evaluative information as opposed to observation, which just fits right in, by the way, into the testimonial hearsay, into Justice Breyer's concurrence in Williams versus Illinois. I really don't see how it's testimonial. And it's important because it's important for you because it's a big issue on who's the first aggressor as to Korea's size. Really matters.
Well, yeah, it does matter, but the fact of the matter is the Commonwealth has not, frankly, raised this issue. I'm aware of generally of the cases that you're talking about, but it hasn't been briefed. The Commonwealth hasn't raised it. I'm going under the current case law as it exists now, that under Revis, the facts and the opinions in the autopsy cannot get into evidence.
And if they do, what happens?
I'm sorry?
The substantial risk of likelihood of substantial.
Yes. Yeah. And there is in this case, because
why?
In the closing argument, the prosecutor cited to the autopsy report about the depth of the wounds and said that, compared that to the knife, and said that that proves, because of the depth of the wounds and the length of the knife, that the knife was plunged in as far as possible and maybe even then some.
Was it cruelty?
Well, not only just to the cruelty, extreme atrocity and cruelty, but also to the intent to commit murder, which would cover both theories. And as to the height and weight, the Commonwealth cited to that for the proposition that Mr. Correa there were 3 witnesses who testified that he was 6 feet and 200 pounds. The Commonwealth cited to the autopsy report of 5'8" and 176 to show that Mr. Correa was not a large man.
Was that really corroborated by the testimony of another doctor?
No. Dr. Miller, he testified that it was hard to say, the emergency room doctor, he testified that it was hard to say because when he was brought into the emergency room, he was lying down.
Yeah, but he still said under 6 feet and 160 to 180 pounds, if I'm remembering the testimony.
He said 160 to 180 and about 6 feet, I believe he said. But the problem with that is that the Commonwealth then asked the doctor, well, did you go look at the autopsy report? That was the next question. And the doctor said yes. And the doctor said, well, is that consistent with your testimony? And the doctor said yes. So the Commonwealth was buttressing the doctor's testimony with the autopsy report and buttressing the autopsy report with the doctor's testimony. So the emergency room doctor's testimony was intimately intertwined with the autopsy. It doesn't stand alone. And his testimony of about 6 feet, I would suggest to you, is not consistent with 5'8". I think there is a discrepancy there.
So bottom line, the reason for the substantial likelihood as it relates to the autopsy report is much of it goes to Commonwealth evidence on who is the first aggressor.
Yes. Well, as to the height and weight, yes, but as to the
Well, also as to the depth of the wounds and the intensity of the wounds.
yes, but that goes to intent and also to the extreme atrocity and cruelty.
The depth of the stab wounds, they had the knife, correct?
Yes.
The knife was retrieved.
Yes.
So they know the length of the knife.
Yes.
I assume the distance between your chest wall and your heart is not that variable among people?
Well, actually it is, because the autopsy report said that in Mr. Correa's case, it was 3 to 4 inches, and the emergency room doctor said, well, in most people, it's somewhere between 4 and 6.
But, I mean, was there any dispute that the knife had reached the heart?
No.
So I'm at a loss as to why all that is that big a deal. So they had the knife, they could see the size of it, and they know that he put it in deep enough to touch his heart.
Yes, but
So I don't know what came in through the substitute medical examiner that would be so important.
well, apparently the Commonwealth thought it was important because they sought to introduce this, and that was their closing argument, is look at what the autopsy report said about the depth of the wounds. And they were stressing that, and they were making the point, which apparently made an impression on the jury, that the knife was thrust in as far as possible, and that it reached these organs, and it had to go in all the way. It wasn't just a little prick, it was in all the way. That was the Commonwealth's argument.
Right, well, I understand why they would make it, but they didn't really need much from the substitute medical examiner. They could say, here's the knife, and you know that his heart was punctured, so you can assume that it was not a slash wound. You can assume it was a stabbing wound.
And they should have done that, but they didn't. And their point was this was thrust in as far as it could go and as forcefully as it could go, and this shows that he really wanted to do this. And that was their point.
They could have made the point, is I think what Chief Justice Gantz is saying, but with having the knife and the fact that it touched the heart, and there's no question about that. Why couldn't they have made the point that way too? And so then, if they could do that, what's the additional harm?
Well, put it this way. If say, for example, the knife was, let's just say it was 8 inches long, right? And it touched the heart, and then it went, and it did that.
Indisputably it did that.
It did that, but the point is that the Commonwealth was trying to make the point that as to the length of this knife, in order to have touched the heart, it must have been thrust in all the way and very forcefully so. And that was their point, that it depended on the knife, the length of the knife in this case reflected on how far it had to go into the body. Mm-hmm. And again, this was the Commonwealth thought that this was a potent argument. I'm sorry.
Go ahead. You were just about to do what I was going to ask you.
The second issue, yes. So the second issue is on the improper admission of Wright's rebuttal testimony. Now, the evidence in the case was that Nason and Wright were sitting in the car, and they were making observations of what was going on both before and at the time. And Nason said nothing was said. After the defense rested, the Commonwealth recalled Wright to the stand, and over the defendant's objection, elicited testimony that Nason had supposedly said, Johnny wants to sucker punch Mikey.
So this issue is really complicated. And I think to analyze it, you have to start with that it's the defendant's testimony, defendant's examination of Nason that brings out what Nason thinks is going to happen as the defendant is approaching Korea, correct?
I don't think they did bring that out, but the Commonwealth makes that claim. But no, the defense did not do that.
So you think that the Commonwealth's comments on what the transcript's going to show as to Nason's testimony is not accurate from the brief?
Yeah, that's correct. He never testified that I thought Niemic was going to go and assault this man. He didn't testify to that.
No, but he said something along the lines of he was just going to go question him, something like that. I'm just going over there he was just going over there to question him, to talk to him, something like that, right?
I don't think he testified to that, no, because before that happened, Niemic was talking with his girlfriend at the scene. He wasn't talking with Nason. So Nason didn't say anything about that. No, he never said that what Niemic is going to do or supposedly do.
So your sister in a moment will say, as I assume she'll say because she wrote it, that this was offered to impugn the credibility of Nason as to something he testified to in his examination, and you're saying that's just there was no basis in challenging his credibility to offer this statement?
Yes, and I pointed out in my reply brief that the Commonwealth makes the claim that they were responding to the defendant eliciting what Nason said Niemic was going to do, and they didn't cite to anything in the transcripts, and so no, there's no authority for that. Nason did testify that he did not expect anything was going to happen when Niemic went over there, but he never said what he thought Niemic
Well, I
was
wasn't
going to do.
suggesting that in my questions. That's the point. He indicated in testimony elicited from defense counsel that he didn't think anything was going to happen.
Yes, but
Okay, so now I understand your point about the extrinsic evidence being offered on the collateral matter gets argued substantively, which is undoubtedly a concern. But what the Commonwealth is going to say is, well, he says, Nason says that nothing's going to happen, he's just going over there, and he doesn't expect anything's going to happen, and that either has to be based on what Nason's sort of evaluation of what it was, or implicitly something Niemic might have said, and that that testimony from Wright, even though misused by the Commonwealth in closing, impeaches Nason's testimony that he didn't think anything was going to happen.
well, let me just read the quote over again of what she said. She said, Johnny wants to sucker punch Mikey.
That's what Nason said.
Nason said, but that's an expression of the defendant's intent by Nason, not expression of what Nason thinks is going to
I
happen.
know, and the problem there is that there's no limiting instruction, and there's a concern that the jury is going to use that evidence as it relates to the state of mind of the defendant, and it was not admissible for that purpose, and you make that point very well. I'm just saying for purely impeachment purposes, the evidence does impeach Nason as to what he thinks is about to happen.
No, I don't think so, because what the defense brought out, I believe there's only one question, and the defense counsel asked of Nason, Did you expect anything to happen when he went over there? Did Nason expect? And he says no. But this statement here is an expression of what Nason's saying the defendant's intent is, which is entirely different.
If Nason says he doesn't think anything's going to happen, and seconds before something happens, he turns to Wright and says he wants to go over and sucker punch him, that impeaches Nason's testimony that he doesn't think anything's going to happen. That doesn't eliminate all the other concerns you have, but it's clearly extrinsic evidence that impeaches Nason. So to the extent you're saying it isn't, I don't even think that's possible. It doesn't eliminate the rest of your arguments, but it impeaches him.
Well, I don't think so. I mean, reasonable minds could differ, I guess. But I guess my point is that the statement in question is Nason saying what Niemic's intent is.
That's fair.
Yeah. And that's problematic.
Was there any claim that Nason was a joint venturer?
No.
So there was no attempt to offer it as a statement in support of a joint venture?
Correct, there was none.
Right. I mean, it was unusual for him to be taking the car, moving it closer, leaving the engine running, as opposed to just parking. It did appear as if he was getting ready for a getaway.
Well, that's the nefarious intent that the Commonwealth wanted the jury to read into that.
Can't say it's unfair.
Well, that's
it's not usually you park, as opposed to leaving the car, moving the car from a greater distance to a shorter distance, closer to the AA place, and then leaving the car running when your friend goes in to sucker somebody else. But nobody, in any event, nobody made the argument, so it's not a basis to admit that statement substantively.
correct, right. And the other evidence concerning that was that this was basically just a pit stop to drop off one person, and they wanted to use the bathroom and were leaving. They weren't there for the time. So, Nason said, basically, we wanted to go. It was, getting dark out and whatnot, and so we were just there temporarily.
Okay, can we go to the closing as your time is coming
Sure.
close? So I know in the first trial, one of the grounds for reversal was the prosecutor's statement that the defendant's statement was not evidence. I didn't read that he said that. I think he said here that there's no reason to believe he's credible. Are you saying that he basically made the same assertion, or are you saying that what he did was close enough?
I'm saying he basically did the same thing, but I think the Commonwealth overstates our claim. We're saying that he said the defendant's testimony about Correa being a bully is not evidence. Not everything that Niemic said was not evidence. And
He used the term not evidence?
that's not the evidence, is what he said.
That's not the evidence. Okay,
Correct.
well, that's a little bit different from his statement is not evidence. Okay, so we're speaking about not the evidence versus it's the word the. The word the is what distinguishes it. Okay.
And that was objected to.
That was not objected to. No. Oh, wait a minute. No, that was not.
So it's just the rebuttal evidence and that's objected to, and what else? Is something else that's objected to?
Well, defense counsel objected as to the sympathy argument about the civilians witnessing this. The judge pointed out that it was improper to use the rebuttal testimony substantively. It's our position that the defendant, once the judge said that, agreed and said, when the judge said, I'm going to give a curative on that, the defendant said, yes, words to that effect of exactly what you just said should be given, that constitutes an objection. But in any event, I cited in the reply brief that the point of a objection is to draw something to the judge's attention so that the judge has an opportunity to cure it. Well, the judge clearly was aware of this issue, said she was going to cure it, and so the purpose of an objection, I think, has been served. In addition to our contention, the defendant did object.
Yeah, no, the defendant never made requested a limiting instruction on the rebuttal witness. I suppose doesn't matter because when you dig down to that, it's still a substantial likelihood analysis, right?
Yes, yeah, right. Just one last issue I did want to raise about the double jeopardy argument on the deliberate premeditation. I want to underscore that in the first trial, what distinguishes this case from the Carlino case is that in the first trial, not only was the jury charged that they needed to find unanimity, But when they came back with their verdict, the judge asked them, "Are you unanimous?" So the jury did not say, we're hung, or we, could not reach a certain theory, or we couldn't decide a certain theory. They said they were unanimous. So then when the jury came back and said and checked off extreme atrocity and cruelty, they were unanimous as to that theory. Their failure to check off deliberate premeditation was a unanimous statement by them that he was not guilty on that theory. There was no ambiguity about it. They said that they were unanimous.
But even if you prevail, he was still found guilty on the theory of extreme atrocity and cruelty.
That's true.
How is it going to help you?
That's going to help us because on the other theories, we are
You think you're going
hoping
to
you were
find that
going
the
to
evidence
reverse
was not sufficient to show that there was extreme atrocity or cruelty? I don't even see you make that argument.
No, but on the other theories, the other arguments were saying warrant reversal, in which case, when it's sent down, the deliberate premeditation theory should not be retried.
I see. Okay. Thank you.
Thank you.
Ms. Johnston.
May it please the court, Tara Johnston for the Commonwealth. Your Honors, with regard to the autopsy report, the Commonwealth's position is that there was an implicit agreement by the parties. And that comes from the entire context and the entire previous discussions between the parties. There was no clear statement, okay, there's an agreement between us. But there had been discussions prior that the defense counsel wanted this cut on the lip of Correa to come in. He was so concerned about it that he objected to the testimony, a substitute medical examiner testifying. But when he was offered the opportunity to admit it, to have the original medical examiner's prior testimony admitted or do a videotape deposition of him, he turned that down because he wanted to be able to cross-examine the examiner on the stand at trial. Fair enough. But then when it came to the testimony of Dr. Niels, the substitute medical examiner, early on in the testimony, the judge said very clearly to defense counsel, you have a duty. You don't have there's no ongoing objection here. That doesn't go here. You have a duty under Nardi, under Durand, if you think that it violates those cases about a fact coming in from the autopsy report, then it's your duty to object. I'm holding you to that. She didn't say I'm holding you to that, but she did say that it was his duty to object.
Excuse me, I don't understand the importance of the implicit agreement, if you're just saying the judge warned about Nardi.
She told defense counsel that you have a duty to object.
I understand it. What difference does it
The
make?
implicit agreement comes later, but I'm talking about the previous discussions which speak to why the prosecutor thought that when he brought this out that there was a implicit agreement.
You're still going to have to deal with the substantial likelihood issue. I mean, the judge could not have been more clear, as you said, in warning about Nardi, but there's no objection.
Right.
And the evidence comes in, and it goes to first aggressor issues and extreme atrocity or cruelty. So assume you're right. We still have to address the issue.
We still have to address the issue of whether or not, if there was an agreement by the parties that it could come in. Here, once the prosecutor started asking about the questions about the cut to Correa's lip, and he asked the substitute medical examiner about it from the autopsy report, the substitute medical examiner said he couldn't see anything from the autopsy report. At that point, right away, trial counsel stood up for defense and said, I have no objection to fact from the autopsy report coming in he did say regarding this. And at that point, the prosecutor said, okay then. He followed up with a question regarding the cut to Correa's lip. From that point forward, he asked additional questions about so what we have in, the additional facts we have in is just about the depth of the wounds, and then about where the position of a couple of them on the back and on the side of the two additional wounds. And then we have, so that it was, and there was 3 to 4 inches, the depth of the wounds in the heart. And then we have on redirect examination about the height and weight. So that's what comes in terms of additional facts. But at no point not only does at no point defense counsel object to this, but when the prosecutor is asking the question about the depth, the inches of the wound, What defense counsel does is stand up to interject and just correct the representation that the substitute medical examiner has said, and to say, oh, it's not actually into the heart, it's the skin surface to the heart.
Yeah,
So
I understand. I guess my question really wasn't clear enough. Okay, so are you saying that we don't then still address whether not objecting created a substantial likelihood of miscarriage of justice, or are you saying, well, to the extent it does, that's going to have to be, if there's an affirmance, a motion for new trial on ineffectiveness under that, and then the issue would have to go through the gatekeeper before we could analyze that?
I think
Don't we review it?
Okay. Well, I'm not saying we don't review it. I guess I'm saying that it's not necessarily error if the parties are agreeing to it. It's similar to, in my view, to a stipulation. I don't see it being much different. The defense
Except
saw it as...
except it's only implicit, not explicit. That's the difference between that and a stipulation.
I agree, Your Honor.
It's known to everybody. It's right on the record.
Ideally,
An
this
implicit,
would...
an implicit agreement is not. We have to read it. We have to read into it, don't we?
Yes, ideally, this would be on the record.
Yeah, ideally.
Ideally, this would definitely be on the record. I agree, Your Honor.
If it's not an agreement and if there's no objection, you need to address whether there's a substantial risk of a likelihood or a substantial likelihood of a miscarriage of justice based on the admission of this.
If this court finds that there is that agreement is not clear enough agreement because it is not explicit, then of course we go to the substantial likelihood.
Why is it not a substantial likelihood?
It's not a substantial likelihood because it was cumulative of other testimony. The prosecutor could have made the same points in closing argument from other testimony that was elicited. To be clear, the 3 to 4 inches, as Justice Gansis points out, Justice Lankus pointed out during defense counsel's argument, it came in through Dr. Miller's testimony. Dr. Miller stated that in order to go through the skin to the heart, it had to go 4 to 6 inches, so a minimum of 4 inches. So this was not an argument that the prosecutor could not have made or pointed out in closing argument without
Well,
that
it wasn't
testimony.
just as to the heart, right? It was that's to other organs as well. One was at 3 to 4 inches through the liver, but he was able to testify from the autopsy reports themselves without any reference to the autopsy report. Dr. Niels was able to testify that it perforated the liver. So I can't to imagine 3 to 4 inches being more prejudicial to the defendant than testimony that it perforated the liver and pictures of this. It's hard to imagine, and that's testimony that the prosecutor would have been completely able to argue in closing argument as well. And also, Dr. Niels was able to testify, and this isn't objected to, that and it should not be because it was an opinion testimony, he was properly allowed to testimony that any of the 5 wounds that could have killed the victim. So, and these are 5 stab wounds, all of which could have killed the victim. All of that came in, and all of that was testimony that the prosecutor could have referenced and to explain why this was a murder committed with extreme atrocity and cruelty. And so for those reasons, it certainly did not create a substantial likelihood. Oh, I also want to address the height and weight, because that's also another fact that came in. And I want to be clear, that was also cumulative. I want to make clear that Dr. Miller did testify that he wasn't just, he was 6 feet tall. That's actually not Dr. Miller's prior testimony. He testified that based on his observations, the defendant was an average size individual under 6 feet tall and between 160 to 180 pounds, which is pretty much exactly right on target to what the autopsy report said. Even without any reference to the autopsy report, there was in there. Also, I do want to make... How tall the defendant was, by the way?
The defendant was, he was also 5'8". I think that came in. They were the same height, but I believe it came in that the victim was more muscular. I don't think there was any question that he was...
The victim was more muscular.
The victim was more muscular, yes.
So,
Even though the defendant won't be a boxer?
Yeah, apparently still the defendant was of slighter build and the victim was the more muscular guy, and testimony to that effect did come in. In fact, Dr. Neal testified even that he appeared to be a muscular guy. So that did come in. And also I want to point out that it was actually defense counsel at trial who cross-examined a few witnesses who did not know the defendant, were just there and clearly saw he was the victim was a muscular guy, but they were cross-examined about this. And during those cross-examination, defense counsel actually asked those witnesses, 3 witnesses, I believe, and I cite to it in my brief that cites the transcript, that he questioned them and said, didn't he appear to you to be a pretty large guy, like 6 feet tall, about 200 pounds? Prosecutor did not object to this, but defense counsel asked those questions of those witnesses on cross-examination, and not knowing these people personally, the witnesses were like, sure, maybe, I guess. So to an extent, this is something that defense counsel brought out, and the prosecutor certainly had the right to ask at least Dr. Miller about what the defendant actually appeared to be, and also the autopsy photographs were before the jury. But to the extent that the defendant wanted to get in that the victim appeared to people to be a muscular guy and that he was a muscular guy, I think he achieved that. I think he actually got that in. And I think when you look at the other testimony, also the cumulative testimony of the fact of the victim's actual height from Dr. Miller, you could see that this would not have created a substantial likelihood of a miscarriage of justice.
Okay, the sucker.
Moving on,
the
yes.
sucker punch. Let's just
Yes.
assume that if he said that Nason did not expect anything to happen, that it was appropriate for you to offer a statement to say, no, he actually did expect something to happen.
Yes.
You still have to deal with the fact that it was not limited in its use to the jury.
It was, Your Honor. It was not, ideally it would have been there would have been a limiting instruction when it came in. That was not requested, it was not given, but it was given later. It was given following the prosecutor's closing argument. At that point, the judge gave a limiting instruction stating that that testimony could only be used for impeachment purposes and you could not draw any intent from what the defendant was thinking or doing.
So he
from that.
referred specifically to that statement during the general instructions? He went back and said...
During the general instruction, she just said that whatever. So during the curative instruction, after the closing argument, she gave that curative instruction. And then during the final instruction, she didn't go back to that statement, but what she said was that any statement that's coming for a limited purpose, you can only consider it for that limited purpose. So she didn't go back to that specific statement, but she did go back that it could only be, what I told you, can only be used for.
It was very good limiting instruction. Judge
Yes.
Dupree, is that
Yes, it is,
And,
Judge, yes.
she did a really good job on it, but the fact is that the prosecutor is using this impeachment of Nason, which really could only have depended on conjecture or something that the defendant said to Nason, and using that extrinsic evidence as to the defendant's state of mind when he approaches Korea. That's pretty significant concern in the closing argument.
I would agree, Your Honor. I would agree that would be I think that would be a greater concern here if there wasn't additional testimony that went to that same point. So I agree to the extent that the prosecutor remarked in those comments that in any way that sucker punch testimony, rights rebuttal testimony, could be used to draw anything from the defendant's intent, that should not have been admitted. I do not dispute that. What I do think is that based on the testimony that did come in properly from Nason himself testified at trial that 2 days before, few days before this incident, the defendant said he was going to punch the victim in the head because of statements that Nason had told the defendant, things that Correa had said about him. The defendant became angry, and he said, I'm going to go punch him in the head. So The prosecutor was also entitled to reference rights rebuttal testimony. I don't think there's any question about this, to show that Nason was not a credible witness when he stated that he didn't expect anything to happen.
Those are good points, but you know what gives me a little bit of pause is in Niemic 1, in analyzing the errors, this court says that the evidence was not overwhelming. Obviously, the evidence is overwhelming that the defendant killed Correa, but meaning it wasn't overwhelming that it wasn't, excessive force and self-defense, for instance. So there's already a determination that the evidence isn't overwhelming when we start to look at these issues.
Was the evidence, excuse me, to qualify that, was the evidence any different at the two trials?
It's pretty close. It was pretty close. I'd be splitting hairs to say that it was. I'd be splitting hairs to say that it was significantly different. From McConnell's perspective, it was overwhelming. I do recognize the court's statement in Niemic 1 that it was strong, but it was not overwhelming. I am aware of that, of course. But from the Commonwealth's position, it was overwhelming. I mean, yes, there is obviously no question that it was a defendant who did this, but from the Commonwealth's standpoint, it's also overwhelming that it was done in self-defense. All of the Commonwealth's witnesses who were...
So we were wrong?
I would leave it to this court's judgment as to whether or not this court views I think reasonable minds could certainly differ. There was a very strong, at least very strong testimony from many people, from many witnesses who had no stake in this case, who weren't even close with these people, that the defendant was the first aggressor. Even the people who testified on behalf of Niemic, Doyle, and Nason, when they testified, we think it was the defendant who threw the first punch. When asked on cross-examination, really, you saw that? No, that was just what I got from it. So nobody actually saw this, the victim ever throw a first punch. There was the only person who testified to that, which is the defendant, which the jury could have found his testimony credible, but
Okay,
there were 7 Commonwealth witnesses who testified that the defendant was the first aggressor.
Yeah, I think you misspoke. You said that Nason, the other person, said that the defendant threw the first punch. I think you meant they said that the victim threw the first punch.
Yes, I'm sorry, I did. Yes, the victim threw the first punch. But in actuality, when cross-examined about that, he pretty much conceded he couldn't really see anything. So
before going to whether or not the prosecutor made the same error in the closing as last time, on the unpreserved error about the victim's reaction to the stabbing and seeing Correa die, as it relates to the father and Correa's statement to the father about "Don't let me die," that was permissible closing as it relates to extreme atrocity or cruelty.
Yes.
Because it goes to the victim as he's dying. Right?
Right, yes. And I think that was actually the only portion that the defense counsel did object to. So I think that was actually, our position is, of course, that the defense counsel did not object to the argument about the rebuttal testimony that was brought out sua sponte by the judge. But the defense counsel did object. The one thing he did object to was he argued that there was improper appeal to sympathy because of the testimony about the victim dying in front of his father. And Judge Dupuy explained that she did not see it as the same thing, that she felt that it was permissible, but she gave a curative or an instruction anyway, a curative instruction anyway, that if they in any way viewed that as an improper appeal to sympathy, to not judge the case on emotion. So, and then I think that brings us to the final issue in the closing argument, which is whether or not the prosecutor made there were the same problems in the prosecutor's argument that occurred in the first trial with respect to the statements about the comments on the defendant's testimony. And I think they were very different in this case. So in Niemic,
Was the same prosecutor, was it?
it was, Your Honor.
Same defense attorney?
It was, Your Honor. I'm actually not sure it was I'm not sure it was the same trial counsel.
Not the same judge?
Not the same judge, no.
Okay.
But the judge was very aware of Niemic 1 in the ruling of it. And yes.
Okay.
She made that clear on the record.
So I assume she gave a reasonable provocation instruction here.
Yes, there's no problem there, yes. So with respect to the words that were used and the context in which they were used, if we look at, so first of all, I want to read Niemic 1. What this court did say, while this court was concerned about the statements that were made in that case, and they felt that the prosecutor went too far with his argument, the Niemic 1 reaffirmed the standing law that it's okay for a prosecutor to talk about the defendant having an interest in the outcome of the case or a bias. He just has to approach that with caution, that argument with caution. And here, the prosecutor followed the directive of the court in Niemic 1. He did approach this case, this argument with much more caution. He did not say, oh, where's the evidence of that? Only from the defendant. And look, he's the one with bias. He's the one with bias. He's the guy on trial. The prosecutor didn't do that in this case. He said, where do you hear about the evidence about the victim being a bully? Only out of the defendant's mouth. Think about who has an interest in this case. I ask you, the jury, to think about the credibility. Who has an interest? Who has a bias? It's your job. Also, he never said there's no evidence of that. And I believe that was a big part of the court's holding in Niemic 1, because it was that the prosecutor was saying that the victim's testimony was somehow inherently incredible because he was the defendant. And here the prosecutor did not do that. The context, when he said that's not the evidence, the clear suggestion of that, what he was trying to get across was that's against the weight of the evidence. Here's all the other evidence that you've heard that shows that that was not the case. Any reasonable juror looking at that argument in the context of everything else that was said during the prosecutor's closing argument, including his statement before that it was for the jury to determine the credibility of all the witnesses, and then comparing all of the testimony throughout, it would have been clear that he was not somehow suggesting or singling out the defendant and saying that his testimony was not evidence. This also would have been clear because the prosecutor pointed out the deficiencies and the problems, the holes in the argument of all the people who testified for the defendant. And also one of the Commonwealth's witnesses, John Voisin, who had an interest in trying to protect his friend, the defendant, and testified a little differently than he did at the first trial. And he was impeached with that. But the prosecutor stressed all of these witnesses, the problems with their testimony. He was not singling out the defendant. And I think any reasonable juror listening to the argument as a whole would have understood as much.
All right, thank you.
Thank you.